Good afternoon, everybody. Thank you for joining us for the next in the series of Beale Company's construction law updates. Following our recent webinar on the topic in February, late payment continues to be a real issue in the construction industry. So we thought it was timely to provide some practical tips arising out of a number of recent cases in the TCC. We will also be joined by Rob Driscoll of the Building and Engineering Services Association, who will discuss an innovative approach to tackling late payment by digitizing the payment process. So, just some brief introductions. My name is Andrew Croft. I'm an associate at Beale Company in the projects and construction team. I am joined today by my colleague Stephen Milne, also an associate in the team. And as I mentioned, Rob Driscoll will be joining us at the end to discuss digitizing the payment process. Before we start, I would like to deal with a couple of usual housekeeping items. The webinar is scheduled to last approximately 1 hour. During the webinar, you can submit questions to us in the appropriate box in the right-hand side of your screen. We'll try to deal with these during the webinar or at the end if time permits. If we cannot deal with a question, we'll get back to you by email after the webinar. Given that we have circa 100 people in attendance today, if you're able to, please can you mute your microphones. So our webinar in February outlined rights under the Construction Act and how to take advantage of those rights to secure payment. If you didn't attend that webinar, it's available on the Beale Company website under the events page. And let us know if you'd like us to send you a link to it. Late payment remains a key issue in the construction industry. The UK government is attempting to tackle it. For example, the proposed payment practice regulations under the Small Business, Enterprise and Employment Act 2015. These will provide from April 2016 that large companies must publish their payment practices twice a year, including, amongst other things, their payment terms, the average time taken to pay, and the portion of invoices paid beyond agreed terms. In addition, the Fair Payment Campaign, the Prompt Payment Code, and the Construction Supply Chain Payment Charter are further evidence that the need to tackle late payment has been acknowledged. But late payment remains an issue now, and this is shown by the limited signatories to the payment charters to date. For example, the Construction Supply Chain Payment Charter, although this was published in June 2015, only has 2 signatories, according to its website on the 5th of October. So late payment is a real issue. Until the last year, there was a dearth of law regarding the payment provisions in the Construction Act, which are key to establishing your payment rights. But in the last year or so, there have been 10 cases regarding the Act, a number of which concern payment entitlement. To paraphrase Justice Aikenhead in Henier Investments versus Beck, a very recent case, there is no doubt that the failure to issue an interim certificate on time has spawned a large amount of litigation. We will discuss in this webinar the practical points to note from these cases, but one general trend is perhaps a keenness on the part of the TCC that payees do not gain an unfair advantage as a result of the procedural notice requirements under the Act, particularly if they have not done what they were required to do under the Act. Because of this, understanding the practical lessons from recent cases and complying with the Act and your contract is very important to securing payment. So in this talk, we'll start with a recap of your rights under the Construction Act and a typical payment process, and then consider the key points to derive from recent cases in relation to payment and enforcing non-payment. We will also provide some practical tips for recovering payment, and as I mentioned, Rob Driscoll will consider moves to digitize the payment process going forward. So I'll now hand over to Stephen Milne.
Thank you, Andrew. So for those of you who attended our last payment webinar in February, some of this will be familiar and perhaps you work with it very regularly anyway, but just by way of brief recap, what we're dealing with here is the Construction Act 1996, which was amended by the Local Democracy, Economic Development and Construction Act 2009, which together we refer to as the Act. The Act, together with the scheme that sits behind it, provides a statutory payment, suspension and adjudication regime. What the Act, together with the scheme, provides is a due date and a final date for payment for any sum which becomes due under a construction contract. It provides a regime, the Act provides a regime for providing payment notices which are provided by a payer, which is normally the client, or payee, which is normally the consultant, yourself, not less than 5 days after the due date, which is the date stated in the contract. If the client is required to issue a payment notice but does not issue that payment notice, then the Act provides for a couple of default mechanisms for a payee notice to be issued before the client's payment notice is due, and that may be a default payment notice, or the payee may issue a default payment notice. The final date for payment is postponed in that event between the deadline for payment notice and the submission of the default notice. If there is no valid notice issued, then payment it wouldn't be due under the Act. So really what the Act is doing is providing a framework for obtaining payment. The recent cases which Andrew mentioned we're going to be discussing have not changed the typical payment process under the Act. It remains as set out in the Act, which requires that you make an application for payment. A payment notice or a default payment notice is required, which can be issued, as we've said, by the payer or the payee in accordance with the contract or the Act. And that payment notice or default payment notice establishes the notified sum. The notified sum is then due on the payment due date, which is calculated in accordance with the contract or the scheme if the contract is silent on that point. Within a prescribed period after the final date for payment, as stated in the contract, or again as in accordance with the scheme if the contract is silent, the payer may serve a pay less notice, and the sum stated in the pay less notice is then the notified sum. And then what the Act says is that the notified sum must be paid by the final date for payment. So far, so good, so clear, hopefully. The process in the Act should end with payment, and if it doesn't, then if you have complied with the process in the Act, you should have an entitlement to be paid, which you can enforce. We will cover some enforcement options later on in this talk. I'll now hand back to Andrew for a little more.
Thank you, Stephen. So, as Stephen was just mentioning, some of the keys to your payment entitlement, whether under the Construction Act or under your contract, include establishing that the Construction Act applies to your contract, your application for payment, if that is required under your contract, any payment notice, both in terms of when you have to submit that and what that payment notice must contain, any employer pay less notice, for example, is that valid and was it submitted on time, and the right to adjudicate for non-payment, and enforcing any adjudication. So, as I mentioned, the TCC has considered the keys to payment mentioned in the slide in the last year or so. Whilst these decisions do not necessarily provide clarity or more certainty in respect of these points, so legal advice should be taken to confirm the position if there is any uncertainty. The decisions which we will discuss can nevertheless provide some useful guidance to you to help you get through the payment process. And it is a key evidence that payment remains an issue that the TCC has spent a significant amount of time considering these points. So, in relation to the first point, when will the Construction Act apply? The route into securing payment under the Act, as opposed to under your contract, requires that your contract is a construction contract. What does that involve? Section 105 of the Act sets out the following requirements. The contract must relate to construction operations. This is a fairly detailed list of operations set out in Section 105. 1 and some limited exceptions in section 105.2. It's important that you look at the facts of your contract and whether it does in fact relate to construction operations. In particular, as highlighted in the slide, it only relates to construction operations in England and Wales, not overseas or in Scotland. The definition of construction operations or in the Act includes a requirement under section 105.1a that the operations form part of the land, and that is something that was considered by the TCC in the last year in the case of Savoy and Spices. The operations in this case were the installation of a conveyor belt system. Did that form part of the land? For something to form part of the land and be construction operations, and therefore subject to the Act, the court considered that this involves more than just looking at whether or not the object is a fixture or a fitting, as you would in property law perhaps. It requires that something is more permanent and sufficiently attached to the land. This is very much a matter of fact, and in this case Aikenhead considered detailed factual evidence and decided that the fact that more than 2,000 bolts had been used to attach the conveyor belt to the warehouse floor meant that the conveyor belt was in fact sufficiently attached and did form part of the land. So it's important that you work out before establishing your payment rights whether in fact the Construction Act does apply to your contract, and this case provides some useful guidance. I'll hand back over to Stephen now.
Thank you, Andrew. So in looking at applications for payment, I suppose if we should say that applications are really a term of art. What the Construction Act refers to are notices, a payment notice or a default payment notice. And depending on what your contract says, your application could be either a payment notice and or a default payment notice. We have found that practices vary from business to business when it comes to issuing notices. The most common approach is to issue an application which is usually in the form of an invoice, which also serves as a payment notice or a default payment notice. But what we would say is that it's very important to check that the application that you issue states that it is a payment notice or a default payment notice and complies with the contract, which should comply with the Act, to provide everyone with certainty about what they're dealing with. It is certainly worth checking that your pro forma applications and invoices are compliant with the contract and the Act. The need for certainty was highlighted very recently in Henier Investments versus Beck, where Justice Aikenhead emphasised the importance of knowing if a document is an interim application for payment because of the serious consequences which flow from such a document. He said it must be clear that it is what it purports to be so that the parties know what to do about it and when. Aikenhead's decision provides a number of helpful reminders and pointers about making valid applications in accordance with your contract and the Act. In particular, to check the application refers to the relevant valuation date under the contract and that the relevant due date stated on the application is correct in accordance with the contract. Preparing your application which complies with your contract and the Act is crucial. But the application must also be valid. What does that mean? Again, two recent decisions from the TCC have highlighted what validity or valid applications must do. Firstly, in the case of Caledonian Modular versus Mar City, it was clear from that what an application must do is to provide the form and content for an application as required by the contract. Your payment application should contain all the information relevant to that application and nothing else, and make it clear that what is being submitted is an application for payment. Again, in Caledonian Modular and Mar, Coulson criticised the contractor for submitting the same application which it had previously submitted and the same supporting documents, and in respect of which a valid pay less notice had already been issued and served. And he also criticised them for not clearly stating that they were making a fresh application that was intended to be a default payment notice. Coulson was particularly critical of the contractor for opportunism. They had been vague about their application, which they had submitted in the course of account negotiations, and then they'd attempted to recast their statement of account as an application for payment. Coulson said that it defied common sense and was contrary to the Act to suggest that the purported application gave the contractor an undisputed entitlement to over £1.5 million. The vast majority of that claim was subject of a valid payless notice, as we've said. A contractor cannot make a fresh claim every few days in the hope that the employer in this situation will take his eye off the ball, as Coulson said, and fail to serve a valid payless notice, giving the contractor, as Coulson said, a wholly undeserved windfall. Coulson said that that would make a mockery of the Act and the scheme for construction contracts. We'll go into the implications of Caledonian again a little later in this talk, but applications, a further point to consider is that your application must be submitted on time in accordance with the contract. This point was considered by the TCC in Leeds versus Waco, where the contract required applications to be submitted on a particular day of each month, valuing the works up to that date. What the contractor did in Waco established a practice of submitting their applications a little late, which the employer had gone along with and generally certified and paid those applications. The contractor then submitted an application early, valuing the works up to a later date, which Mr. Justice Edward Stewart said was not a valid application for payment. Reconciling the two decisions there, the one in Marr and the one in Waco, it can be difficult, and in addition, one we've not mentioned yet but we'll come to later, the decision in Civic. Those decisions don't sit too easily together, and they can be a lack of clarity. But the key principle to take from those decisions is to be very clear that you are making an application for payment and that your application is a payment notice or a default payment notice, and to check it again that your application complies with the contract. I'll hand back to Andrew now for a little more about the content of payment notices.
Thank you again, Stephen. So, submitting applications for payment, and in particular payment notices, is no time to be coy, as Stephen was just saying. You must be clear that the notice you're submitting, i.e. the invoice or the application, is a payment notice, and that notice in itself must be clear. As Coulson said in Caledonian and Marr City, if you intend to serve a payless notice, you should say that that is what you are doing, and that's what the payee failed to do in that case. So a couple of practical points to take from the cases regarding payment notices. Firstly, be as clear as possible that your application for payment is a payment notice, and state that both on the notice and in any related correspondence if necessary. In addition, it's very important that the payment notice is calculated in accordance with your contract. For example, in Henier, Aikenhead said that the application must be for the sum due at the relevant due date, which were the dates set out in the contract. Whilst it was not absolutely necessary to refer expressly to a specific date, it must be clear that an application related to a specific due date was being made. The Construction Act requires the payment notice or any default payment notice to set out the amount due and provide an explanation as to how that sum has been calculated. So it's therefore very important that your application for payment clearly includes some strong backup to set out how the amount due has been calculated. In addition, it can be really helpful in drafting a payment notice, and perhaps in some cases essential, that the way you calculated the sum due is linked to your entitlement under your contract, and it's not just putting a finger in the air, perhaps. So I'll now pass back over to Stephen.
Thank you, Andrew. So we're just going to look now a little more detail in relation to the timing of payment notices. So as alluded to earlier in our presentation, payment notices must be submitted on time. But in the real world, sometimes things don't run accordingly to plan. So if you submit a payment notice later than the date stated in the contract, then depending on what the contract says and on what has happened previously, which is something we discussed when talking about Waco, the decision in Waco, your payment notice may not be valid if it's been submitted late, particularly where the contract provides for periodic valuations and states that no sum is due unless the payment notice is submitted on time. So it is worth making sure that your internal procedures align with what your contract says to give you the best chance of securing your entitlement to payment. It is also worth bearing in mind that even if your payment notice is late for being a payment notice, it could still be a default payment notice depending on the circumstances and what your contract says. So the question then that we've raised there in the slide, is it better to be early than late? Well, following the decision in Waco, you might be thinking, no way, it must be better to be late than early with my payment notice. However, there can be subtleties in contract drafting which need to be considered. We've discussed the case of Henia, where the drafting of that contract and the relevant clauses asked the contractor to state the sum the contractors considered will become due. And the use of the future tense there permitted the contractor to claim and allow for work that it anticipated it would do between the date of the interim application and the payment due date. So the right answer to that question is it better to be early than late? Well, the right answer is to be on time. That being said, it is better to set yourself up to issue your payment notices early, provided that the payment notice relates to the due date stated in the contract, it values the works up to the date in accordance with your contract, and you should also make sure that what you are doing is consistent in overall terms with the payment cycle under the contract. I'm going to hand back to Andrew now in relation to payment notices and pay less notices.
Thank you, Stephen. So this is perhaps one of the key points under the Act, particularly as amended. What happens if no payment notice or pay less notice has been served? And the case of ISG and Civic, which came in the TCC last year, is a key case in this regard. This provides that if a valid pay less notice is not served, the payer must pay the notified sum stated in the payment notice or the default payment notice, and that notified sum is the amount due. Additionally, in the Civic case, Edward Stewart J says that absent a valid pay less notice, the payer is deemed to have accepted that the value of the work stated in the payment application, i.e. the default payment notice or the payment notice, is the valuation of the works at the date of that notice. And this suggests that a payer cannot bring an adjudication to challenge the valuation of the works in a payment application if there has been no pay less notice, essentially in response to any adjudication to claim the unpaid sums. Edward Stewart J's rationale appears to have been that such balancing matters can be dealt with in later valuations or at the final account stage. And this was the reasoning followed by the court in Galliford Try and Assura, where Edward Stewart agreed that the employer could challenge the proper valuation of works in accordance with the contract in a later application or valuation cycles if they had previously failed to serve a payless notice. So, what must be contained in a payless notice? This is another issue that the courts have considered in the last year. A payless notice can include and allow deductions and other set-offs which the employer is entitled to make or claim under the contract. So in Henier and Beck, the employer was entitled to challenge an application by putting forward its own valuation of the works. The post-CVIC cases may provide some arguments to help throw back the situation where payless notice has not been served. But the bottom line is that absent a valid payless notice, the amount due must be paid by the final date of payment. So if you've served a payment notice or default payment notice and there's no payless notice and the final date of payment has passed, it's important that you act quickly so that you don't get into a position at the next step in the payment cycle where the employer can decide that a lower sum was in fact due. So Stephen's now going to consider what you should do if a sum hasn't been paid by the final date of payment.
If you have not been paid, then the ball is really in your court as to what you're going to do next. There are a few things which you can do which aren't mentioned in the Act, and we'll come to those ones a little later in this presentation. But one of the strong rights under the Act is the right to adjudicate in the event of non-payment. So if there is no satisfactory explanation from your employer as to why they haven't paid, then adjudication is a strong tool which provides you with a relatively quick and hopefully inexpensive route to getting judgment from the court to enforce your entitlement to payment. Adjudication itself is a 28-day blunt justice mechanism. Notwithstanding the potential for mischief and wrong decisions, the courts have proved extremely reluctant to interfere with the adjudicator's decisions. The courts are particularly reluctant to open up disputes unless there is a good reason to do so, which normally means that there's been some breach of natural justice or some possible potential bias on the matter in relation to the relationship with the adjudicator. This reluctance from the court is there even where the adjudicator did not see all the relevant documents and did not ask for further submissions, even where the full evidence would establish, for instance, that a payment notice had been served on time. And that's what happened in Broughton Brickwork versus Parkinson. In Broughton, His Honour Judge Stephen James, who's sitting in the Manchester branch of the TCC, said that this decision may leave the defendant with a sense of injustice, but that is part of the rough and ready nature of the adjudication process. That being said, in that case, in the case of Broughton, the parties had respectively refused and or failed to lead the adjudicator through the relevant facts and direct his attention to the relevant documents, which they could and should easily have done. And so the mischief in that case was perhaps of their own making. But the lesson coming out of Broughton is that an adjudicator must be guided through the arguments and taken to all the supporting documents. This is not always easy to do in the short timescale, a 28-day timescale of an adjudication, especially where there may be several issues circulating in the dispute. However, leaving the adjudicator to take steps in reasoning on a party's behalf or trawling through documents on his own may lead to an argument about natural justice or an incorrect decision, which is going to be nevertheless enforceable by the court. But that leads to the question, well, when might enforcement be refused once you've got an adjudicator's decision? I'll hand back to Andrew now to talk about that.
Thank you, Stephen. So, as Stephen was mentioning, the courts have generally been reluctant to refuse to enforce an adjudication. and the general rule seems to be that adjudications will be enforced unless there is a breach of natural justice, or perhaps bias, or a lack of jurisdiction on the part of the adjudicator. And the bar for this has generally been quite high. However, the courts recently refused to enforce an adjudication decision in full in relation to a payment case which we have discussed previously, Galliford Try and Estura. And this was on the grounds that enforcing the adjudication would cause manifest injustice. Essentially, the employer argued that it was not able to pay the adjudicator's decision or the amount awarded in the adjudicator's decision, and to require payment in full would result in manifest injustice. So, in reaching the decision that the employer was in fact right in its arguments, to some extent, the court applied HHA Toulmin's CMG QC's observations in Hillview and Bott, and said that an unusual combination of factors gave rise to an irreparable prejudice to the employer if the adjudication decision was enforced. And key to this was the financial position the employer was in and its ability to pay. As a result of this, the court granted summary judgment for circa £3.9 million plus VAT and interest, and stayed enforcement of the judgment above the sum of £1.5 million, subject to certain conditions, including ones aimed at ensuring the contractor had an incentive to achieve practical completion and submit its final account. What does this mean for you? It's very important to keep the employer's financial position under review and carefully consider their ability to pay before incurring the costs associated with adjudication and or enforcement, in the event that they come up with similar arguments to Estura. So now Stephen's going to consider what to do if you disagree with an adjudication's decision.
In the recent decision, a very important decision from the Supreme Court in Aspect Contracts, Asbestos Limited versus Higgins Construction plc, the Supreme Court confirmed the position that an adjudicator's decision is binding until the dispute is finally determined by the courts. In Aspect, the adjudication was carried out under the scheme. In the leading decision of Lord Mont's, the Supreme Court said that the unsuccessful party in adjudication has firstly the benefit of an implied term entitling it to recover any overpayment that the adjudicator's decision has led to once the court has finally determined the dispute. Second, that they had the right to seek a final determination by suing on the implied term, which arises on payment of the sums the adjudicator awarded against it. And in relation to that right, that they had 6 years from the date of payment to seek final determination and recover any overpayment. In other words, the limitation period for the paying party to seek final determination of the dispute starts to run from the date of payment of the adjudicator's award. The Supreme Court also held that it was the dispute as referred to the adjudicator that was to be finally determined. Following the decision in Aspect, one practical tip, which again might cut both ways depending on which side you are, is to amend the contractually implied term to provide for a shorter limitation period for final determination of adjudication awards. We're going to briefly move on now because we're taking time. We're going to deal with practical tips coming out of these recent decisions.
So we've considered how the TCC has looked at payment in the last year or so and payment under the Construction Act. And we're now going to look at some practical tips which may assist you in obtaining payment going forward. Firstly, your contract alongside the Act is key to understanding and establishing your payment entitlement. So it's important that at the outset of a project you know which contract you are working under, and you don't end up in a battle of the forms type scenario where you and your employer each think a different form of contract will apply. This will create uncertainty and make it more difficult for you to recover any sums due. So the key thing is to make clear at the outset which contract applies before you start carrying on work. In addition, before you start carrying out any work or services, it's important that you understand how you will need to apply for payment on the project. This is both in terms of clearly understanding your contractual requirements, i.e. what you are required, when you are required to submit notices, etc. And we are increasingly seeing very onerous requirements being included, particularly in contractor drafted appointments or contracts, which require very onerous condition precedents to be complied with before an entitlement to payment can arise. This might include that invoices are submitted to specific offices or include specific wording at specific points. And arguably, if you don't comply with those requirements, the contractor might say that you're not entitled to payment. In addition to understanding your contractual requirements, it's also important that on a practical level, you understand who is responsible within the payer for approving your invoices, etc., where they must be submitted, etc., and what those parties expect from you. And I can't see that there's any harm in establishing contact with those people right at the start of a project before you've even had to apply for payment, just so you know what the ground rules are going to be. In addition, it's important that during the course of a contract, you follow each payment cycle carefully. So having established what you're required to do under your contract in order to be entitled to payment, clearly sets out what is needed and make sure that everybody in the team is aware of that and complies with that during the course of the contract. And follow each payment cycle carefully. In addition, during the course of a contract or of a project, don't be afraid to be contractual if you become entitled to additional payment. For example, if you've carried out additional work or services, or if the project has been prolonged. If that happens, pull the contract out of that drawer, get rid of the dust, and find out exactly what you need to do to be entitled to payment. This is important because a number of contracts these days contain condition precedents to your entitlement to additional payment. And if you don't provide the required notice within a sufficient time, you may lose your entitlement to additional payment. Finally, if a payer operates pay when paid or pay when certified behaviours, which are clearly not compliant with the Construction Act, it's important that you clamp down on this as soon as possible and let them know that what they're doing is not compliant with the Construction Act and probably won't be compliant with your contract, assuming that your contract complies with the Act. So I'm going to hand over to Stephen, who's now going to cover a few more practical tips.
So there are a couple of other things perhaps internally to be looking at too. Firstly, is to review your own internal procedures to ensure that you have in place a process to manage non-payment or manage invoicing, non-payment and debt recovery if that becomes necessary. I think one of the common themes that comes out of the various cases is to be prepared to respond promptly and to deal with your client quickly in the event that they do not comply with their payment on obligations in the contract or the Act, particularly if they fail to serve the right kind of notice at the right time. A further thing to consider is whether the employer is perhaps in breach of any payment charter, which you could then perhaps notify to the relevant authorities in order to flag up their failure to comply with the same. One point on the slide is to consider some sort of decision tree, an internal decision tree that's triggered when there is non-payment, which might lead to such matters as perhaps a strongly worded letter escalating the position perhaps to internal managers or directors within the employer in order to get the situation to the attention of the correct parties. Sometimes these issues get stuck at the site level, and that sort of letter, or a sort of letter that notifying their non-compliance with some sort of charter, can get the issue away from the site level up to the senior management or director level, which can be really helpful in breaking a deadlock if there is such in relation to a non-payment. And as a final point, and I guess we would say this as lawyers, don't be afraid to turn up the heat if you're not being paid and there's a continued practice of non-payment. But one thing that we would certainly be advising you to do is to get legal advice before taking any steps to suspend performance of any works that you're doing or adjudicating. Both of those are very serious steps, particularly suspending, and you need to be very confident and sure that you're doing that in accordance with your contract and the Act to make sure that you're not in a situation of perhaps breaching your contract by non-performance. And in relation to adjudication, well, as we've discussed, the courts are reluctant to interfere with decisions of adjudicators, so it's very important to make sure that your adjudication is prepared on the right basis, that the adjudicator is directed towards the right documents and the right submissions are put in, so that you are doing your best to make sure that your case is put forward as fully and fairly as possible and that you get the right adjudicator's decision at the end of the day. So now, just as we mentioned at the start, we're going to move along in our presentation, and I'm going to hand over now to Rob Driscoll of the Building Services Association, who will consider a practical approach to tackling late payment by digitising the payment process. Rob.
Thank you, Stephen. I guess I'd like to start by introducing myself. The guy said I work for the Building and Engineering Services Association. Who are they? Well, they're a body that represent nearly 1,400 contractors within the supply chain at tiers 1 to 2, 3, 4. We also dovetail into the Specialist Engineering Contractors Group, which has another 5,000 contractors within the supply chain, and we also sit within Build UK's structure, which represents the single voice for the entire industry. There are over 40 specialist engineering trade associations and all 32 of the big household name main contractors. So give you an idea of where we sit in that structure and what we see. And I'm just going to draw you up to a higher level first, because part of my job is also to look at the structure of the market and become a bit of a amateur politician and economist before you can work out the day job of being a lawyer, because I am a solicitor and mediator too. Just to give you a look at your market in the construction, and I mean by construction, hard FM construction in terms of its conventional and infrastructure, you're looking at what amounts to 10% of the economy, or 6.7% of the economy, 10% of employment, over 280,000 businesses. Now, the interesting demographic on the right there is 280,000 businesses in construction. 84% of those are SMEs, and 99% of that 84% are single-man businesses, which really does show you how disaggregated a sector we are and how fragmented we are. Going over here and showing you the pyramid structure, conventional construction, contractual routes, regardless of which contract you pick or how the legislation works, most of the work and the value is done down at tier 2 and 3. I don't think anyone would argue with that. So your tier 1 and 2 contractors generally provide the sophisticated management techniques that perhaps the smaller businesses don't have in place. And that's no bias towards one or other. That's just simply the way the structure works. And these are facts that have now been verified by the government. People touched on earlier the impact of late payment. I will talk about where the government's role in this is in a slight second, but we have just been through 3 rounds of recession in 7 years as a market. To give you an idea of how constricted it, we dipped by over 8% in terms of our output. We had a political mandate on us from Sir Francis Maude under the coalition government, where we were to cut the cost of construction in this country by 20% if we were going to compete competitively on an international stage. But then if you look at our market, a large percentage of our consultants do export, but only 6% of our contractors export across the economy. So our contracting side of the economy is very much introverted, whereas the consultancy side is very much extroverted in terms of international versus domestic. So I think it is important to understand how the market works before you look at the legislation and how that can help things forward. We're also, so I touched on the need to increase efficiency and deal with waste. Sir Francis Maude's edict resulted then in a mandate about how we are going to push along BIM. But to go back to payment, the perennial question of how do we resolve payment issues? Well, so bank lending to our area dipped by over 30%. Across commerce generally, it was only 5%. So there was no banking facilities to get us through the recession. We're in the upturn. Half the construction sector's fully out of the recession. The last half, that runs 16 months behind the front end of the economy, is still emerging from it and trying to get rid of some of those loss-leading contracts which it bought in order to get through the recession. So payment we've always struggled with. You go back even before Latham and you had Banwell reports, and every 20 years there was a good report issued saying how the construction economy wasn't as good as the aviation or the automotive. We went through Latham, and it was my predecessors in my organisation that sat alongside Sir Michael Latham and got the Construction Act as was in place. We asked Gordon Brown again in the late 90s to have another look at it, and it took 8 years before we had the 2011 amendments. I might say that the results weren't necessarily what we asked for. And the idea of the legislation that the guys have described is simply communication on payment, so that we know the dates on which we can be told what we're going to get paid, so that we can manage our cash flow. This slide, just gives you an idea of the amount of costs involved that are put back into the price of the product in order to counter and make contingencies for late payment in our industry. So moving on, we've talked about the disaggregation of the supply chain. Equally, the public sector accounts for 40% of the client base in the industry, no matter what area you're talking about. This just gives you an idea of how disaggregated the public sector is. We talk about it as if it's one amorphous body. It's not. It's several thousand procurement bodies. This is just an idea of central government procurement. There is a lot more than that at hand, and due to an edict within government that they cannot tell each other what to do, because it would be abuse of a dominant position in terms of EU competition rules, they end up acting as several separate bodies. This is an idea of the policy landscape, and yes, it is a number of policies within government that have been rolled out in the past few years. And yes, it's confusing because, quite frankly, you deal with several different departments on several different levels. But this gave rise with us to an idea conceived about 2 years ago, that as the emergence of BIM was coming onto the market, and going back to my day job, just like Stephen and Andrew, it's about dealing with Construction Act issues for members of the supply chain, acting as either consultants or tier 1s, 2s, 3s and 4s. It's not clever or conducive to use the Construction Act as a weapon to hijack relationships in order to get one-off payments, because it doesn't create good commercial relationships going forward. And if you don't have solid commercial business relationships, as you all know, it doesn't create a steady business model. So we looked at that and said, well, if you look at other areas of commerce like retail or travel, or what the government's done with the driving licence authority and its integrated approach to technology there, the answer surely is to create a system whereby you take the framework of the Construction Act and you digitize it. In essence, it provides 4 or 5 dates described in chronologically: application, due date, payment notice date, pay less notice date, and final payment date. And it provides 2 bits of paper. And they are still seen as pieces of paper in the industry, whether they're sent by PDF scans, emails, or whatever else. It's still a distinctly analog industry that we work in. where those pieces of paper are sent across their desks, and sometimes they got forgotten or missed. And the large number of disputes are purely down to that reason. But once we get entrenched in our positions, it's very hard to roll back from those. So we have systems whereby, whether we're talking about large consultants or contractors, sometimes an accounts division is one part of the country. Any other, the largest tier one contractors can have over 600 sites operating at one point around the country. And the surveyor or the person in charge of actually certifying the money is located in another part of the country. So you get stuck as to how you even chase payment, because where do you start if you're the one being paid? And if you're the one paying, it might be that you've got a number of other issues, either in work or personal life, that mean that things do occasionally get missed. I said to look at other areas of commerce and how they help us manage this. If it was retail, you'd look at Amazon and how that sends e-alerts. So, and looking at the last slide where we talked about the government's, for example, digital by default strategy and value for money strategy, the integration of driving licence authorities system with passport control and other systems there led to a 70% cut in their overheads practically overnight, as well as de-risking the system. And really that's what we're talking about. If you can automate the Construction Act so that there are electronic reminders of what to fill in and when, and preordained forms that comply with the contract, the Act, then you start to de-risk and declutter. And you start to unlock within each of your businesses where the process gets stuck. So yes, I've been talking to government, at Treasury, Cabinet Office, and a number of other areas about putting something in place, and we didn't quite see where it would come from. Along comes into the market Textura, which we're not seeking to endorse one specific solution, but at the moment, they are the only solution in the market that provide two things. They provide the online payment construction payment management platform, it's called, which helps actually provide the software solution, and some tier one contractors are already on board with that. They came out of the US market, they are active in the Australian market, and they have wrapped their solution around the legislation in this country to provide the same solution. It's also backed by a bank called Greensill Investment Bank to add supply chain finance in there, which is a bit of a Marmite issue in terms of some people are extremely pro it or extremely against it. Our political position is it was introduced by the Prime Minister at the time as a good initiative to provide liquidity into the supply chain, and provided it's not abused, then fine, it provides another solution to an agile supply chain to access finance when needed. It's only the abuse that we're against. So really that's a very quick summary of the economic, the political landscape, and why we're looking at an industry that we all know in the sense of BIM is on the verge of tipping into the digital era, but may very well be looking at digitizing the business process that underpins construction, as well as the design, supplied, install and construction process behind it. Thank you guys for letting me come and guest on your webinar.
Thank you very much, Rob. That was a really interesting look into the potential future of payment in the construction industry. And as Rob mentioned, it ties in very neatly with the increased digitization of the industry as a whole, by reference to building information modeling and the general move towards things like smart cities. And hopefully there will be an increased adoption of this sort of approach to payment to try and reduce disputes about non-payment, and obviously to reduce late payment. So I'll now briefly summarise the key things we've discussed in this talk. Late payment remains a key issue in the construction industry, despite the government's tentative efforts so far. And that's been shown by a number of cases in the TCC in the last year or so. Complying with the Construction Act remains key to establishing your entitlement to payment, as well as complying with your contract. It's important that at the outset of any project you understand the payment process in any contract, and also how practically you will apply for payment It's also key to follow the payment cycle during the course of a contract and take that contract out of the drawer in the event that you think that you're entitled to additional payment, or simply when you're applying for payment to ensure that you are complying with that. In addition, if you comply with your rights, if you understand your rights and comply with your obligations under the Construction Act, you're going to be certainly in a better position to establish your entitlement to payment than you will be if you haven't. Finally, new approaches such as those which Rob was just discussing will hopefully help tackle the issue of late payment in the construction industry. So before we finish, I just wanted to highlight that Beale Company will be hosting another webinar on the 11th of November at 1 p.m, which will consider the duty to warn following recent case law on the subject. Further details on the talk are set out in the slide. If you're interested in attending this webinar, please let us know at the email address on the slide. Finally, please let us know if you would like any help in relation to the matters discussed today, including in relation to any outstanding fees or looking at your internal procedures, and my contact details and Stephen's contact details are on the slide. We've had a number of helpful questions during the course of the webinar, and we've responded to those which we could during the time available. If we haven't got back to you yet, we'll get back to you by email shortly. It remains for me to say thank you very much for listening to me, Stephen and Rob this afternoon. And as I said, if you do have any queries in relation to the issues we've discussed, do not hesitate to get in contact with us. Finally, we'll be circulating a link to a recording of the webinar and the slides to the attendees in the next week or so. Once again, thank you for listening.